Derivative claims. So this would engage certain concepts which we have read before, such as separate legal personality of the company, the majority rule by which a company is run, the the consequences of separate legal entity is that company, as we have read before, can sue or it can be sued in its own name. So what does it mean by suing is that it has a legal capacity and the standing to bring an action before the court where it is wrong. But at the same time, we also know that the shareholders have entered into a contract with the company which can give rise to, and contract, it can give rise to actionable remedies such as damages, specific performance, declaration. They can seek declaration from the court, and host of other remedies. So we see we derivative claim here. The thing claim specifies is action that can be brought before the court. Derivative means it is derived. Where is such claims which are derived from some specific legal right, and this is what we will study here. So, in this chapter, we're going to talk about the interaction of various principles of company law in the context of private companies, and it engages the company contract section under section 33. And he gives a very concise introduction in these paras. He says that it is not overstating the matter to observe that the majority rule principle pervades much of the company law, as it touches upon the issue of who owns and control. And remember, the problem with company law, understanding the concepts, is it's difficult sometimes to understand the differences between ownership and control, because this is separated. Shareholders have the ownership, the management controls. Sometimes both same person can wear two hats. But at the same time, owners have the proper contract with the company. Management does not have a contract with the company under section 33. Whereas shareholders may have contracted with the company regarding their rights as outsiders, but those rights, outsider rights, as we have read before, do not arise. But the main problem here is how the majority rule interacts with the separate legal identity. Companies ultimately going to be run by people who are in the management and have majority. And at the same time, shareholders also make decisions about company. There are many decisions which they have to make, especially if the company's articles require them to take certain decisions regarding certain transactions. And we'll see in props later on that there is a provision in the articles that if any transaction is being done above 10 lakh, you need to get approval of the shareholders. The directors need to get approval. And what if they don't do it? If it is unauthorized, who can take the decision? Now, in this situation, let's suppose if there's a clause which says that you need a ordinary resolution, which means more than 50% from shareholders to authorize a purchase or sale of asset, purchase or sale above 1 million, and the directors don't get it, and because they are managing the company, they really have the keys to the door, to all the doors, but sometimes you need approval and they don't take the approval, they go back door. What happens? Now this is clearly a breach of the company articles, it is a breach of the contract which the director would definitely have with the company as well, is that they have to observe the articles. Now this is a breach, it gives rise to a claim. Who can bring this claim? Can the shareholders do it? Can an ordinary shareholder whose vote had to be mattered, because they would have voted on it, and suppose that shareholder is in minority, what remedy does she have? The problem here is that the company is run by majority. Majority of shareholders decide what to do. They decide on whether to pursue a claim or not. In this case, the court will ask first question is whether can the majority accept this breach or not. If the majority can accept this breach, then individual shareholder has no right. No right. This is a consequence of majority rule. This is a wrong which was done to the company, and company decides it through the majority under the articles. Here, if company chooses to authorize this transaction, let's suppose this transaction is not fraudulent, it's an ordinary business decision. It happens with companies, they have to decide very fast, and it becomes sort of in props. There are questions I've seen where they have written that it was normal for directors to go ahead with the business deal and then seek authorization later, and they got all the authorization in the past, and now they did it again. So the question would be whether individual shareholder can bring the claim. Answer in any case would be no, they cannot, because majority reserves the right to whether accept this breach or bring a claim against the director. Because company is a separate legal person. It is run through the majority, but still the majority, if the majority decides to bring a claim against director, they would bring it in the name of the company. So this is the starting point, and we'll build on this, that in which situations can an individual shareholder bring a claim despite the majority rule. So they say, firstly, in this chapter they talk about the remedies which are available to the shareholders. Majority principle and remedies available to shareholders when the majority rule is abused. Another remedy is in the shape of unfair prejudice, which we'll discuss in the next chapter. And now again, he's mentioning the consequences of doctrine of separate personality is that the company can sue or be sued in its own name. Because company is a legal entity, it can sue to enforce its legal right, and can also be sued if it breaches someone's rights. It is generally not open to shareholders. The reason may be is to avoid floodgates of unnecessary litigation, and as well as the basic norm of a company is it would negate SLP, it would negate the right of majority. Just like laws are made by majority in the parliament, the minority cannot say only on the basis that we are a minority and this law is not right. The law would be checked on touchstone of whether it breaches fundamental human rights or whether it breaches some other core constitutional principle. It will not be even reviewed by the court mainly on the basis that the individual legislator has the right to review it. So this is clearly the case here. And however, every rule has an exception. There are competing principles which are to be analyzed. The rationale for this is given by Greer LJ in the case of John Shaw versus Shaw. If the powers of management are vested in the directors. They, because once you decide the ground rules, you have to observe it. You have to logically follow and logically, you know, ensure that those basic precepts are followed. Otherwise, you'll be completely destroying the whole foundation on which company law is built. The only way in which the general body of shareholders can control the exercise, the general body of, that means the majority, can control the exercise of powers vested by the articles in the directors. They can alter the articles, they can, refuse to re-elect directors or remove them, and this is how they control directors indirectly. Shareholders cannot run day-to-day affairs, but indirectly they can still hold them accountable. They cannot, shareholders, usurp the powers by which articles are vested in the directors any more than the directors can usurp the powers. So directors, if they are in breach of the articles, shareholders will bring a claim against them as a majority if they have the right. Otherwise, it will be the company. If some individual director is breaching an article or is not following the procedure, it is up to the directors as a whole to bring an action against that person. If the law were to allow minority shareholders unfettered standing to sue, there would be a real risk of the floodgate argument. But the problem is that there can be directors who are also part of the members, and they have majority. They can block any attempt by the company as a whole to bring a claim against that individual because they may be in control of the shareholding as well. Now, the other consequence, the other building block which you need to understand is the contractuarian basis of the company under Section 33. The company is bound by the articles and memorandum and to company's other shareholders. The articles are self-binding on the company and as well as to the shareholders, each shareholder. So this lays down the relationship between members and members inter se. There's currently no separate contract between members inter se. However, a member also, when she enters into the article association, is bound by the decisions. She accepts that she will be bound by the decisions of majority taken at the general meeting. So if the company decides as a whole, members decide as a whole, not to enforce an article against a director in our example before, for unauthorized transaction, individual cannot bring any claim against it because she is also bound by the articles, by the majority rule. They can dissent, they can vote against a certain resolution, but ultimately the majority would have the day. But once a resolution is passed by the appropriate majority, a dissenting member will be bound by it. Just like when elections happen and 51% of votes are given to a party, that party has the right to form the government. Similarly here, resolution would be binding. So this is again another consequence of majority rule. And furthermore, the reason why majority rule is made is to allow companies to self-regulate, to develop their own rules. It is a power conferring rule which allows companies to act like legislatures within their in the affairs of the company. And the consequences therefore is that courts have been very, very careful not to interfere in the internal management of the company. Internal management rule is also very applicable because certain normal procedure irregularities which can be rectified easily or not, but legally if it can be rectified by the majority, then courts will not interfere. Even if it seems like that this is a bad scene for the company. As long as there is no fraud, there's no other basis There are very limited circumstances in which court would interfere, and this is what derivative claim is about. It's one of the remedies. So this non-interventionist policy was also expressed in Carlin versus Dury case. The court is not required on every occasion to take the management of every playhouse and brewhouse in the kingdom. This is what liberal economics, economic theories posit, that we need to give space to private parties to organize their affairs and to decide their disputes themselves. So minority shareholders, they have very weak position, and it gives a lot of control to the majority. And there's a weak bargaining, there's inequality, and there is very unequal bargaining power between the parties here. They do not have any de jure control, nor do they have de facto control. And but another problem is the the imbalance between the shareholders and the directors. Let's suppose that there is no shareholder who has legal, in terms of majority, or de facto control. The directors have unlimited decision powers. And now we need to find, the law also seeks to find balance between majority rule and protection of minority shareholders, so that they don't abuse their power. The beginning analysis is the case of Foss versus Harbottle. It gave the proper claimant rule, and that simply is that where there is any wrong done to the company, then the company has the proper authority to bring the case against anyone. And the facts was that Foss and Turton, they were two minority shareholders in the company. It was set up in 1835 to buy some land, and then there was a law which made that land Victoria Park. An act of parliament then incorporated the company. The claimants alleged that the property of the company had been misapplied and wasted, and various mortgage finances were given improperly over the company's property. They asked the guilty parties be held accountable to the company, and a receiver to be appointed by the court, so that they can recover any profits made by the directors. The defendants were 5 company directors, as well as some other parties as well. Now, Vigran VC gave the judgment and dismissed the claim, and that when a company is wronged by its directors, it is only the company that has standing to sue. In effect, there were 2 rules established. Number 1 was the proper plaintiff rule, the proper claimant rule, that when a wrong is done to the company, it may be vindicated by the company alone. Company can either accept that wrong, authorize it, rectify it, or bring a claim. And the second is the majority rule. Because majority rule states that if the alleged wrong can be confirmed or ratified is the proper term, by a simple majority of members in a general meeting, that court will not interfere. He gave a long judgment. He gave complete reasoning, arguments in favor and against it. And I will not go through that, but I will send you some quotations from this. So this rule was then further extended in cases it still applies, it still holds its ground. And in one of the cases where it is routinely applied is where there is an internal irregularity in the operation of company. And if that internal irregularity is capable of being confirmed and sanctioned by majority, it will be the company which can bring the claim, and a shareholder will not be able to recover any reflective loss, any consequential loss, any reduction in the value of their shares due to those decisions. The proper course is for the company to bring the action, and then the company can recoup or recover the loss, and then which can restore the value of the shares. However, this you can see that it leaves the minority shareholder in a very unprotected position. It puts them in a very vulnerable environment where the majority can do whatever they want, and then they can get everything ratified by the majority to the detriment of the minority shareholders. And then in Edwards versus Halliwell, this rule was further explained by Jenkins J. Again, first thing was the proper claimant rule, and then it said that where the alleged wrong is a transaction which might be made binding on the company and all its members by a simple majority. If there is some wrong transaction, but it can be made binding through a resolution, then no individual member is allowed to maintain an action in respect of that matter, for the simple reason that if a mere majority of the members is in favor of what has been done, then in other words, they would rule. This particular formulation was then given a broader context by Lord Davey in Burland versus Earl, and they further, conceptualize this basic concept. It is an elementary principle of law relating to joint stock companies that the court will not interfere with internal management of companies. Companies are self-regulating, fully empowered persons in private matters. They can decide for themselves whether to rectify a wrong or not. When the court will not interfere where the company is acting in its power, and court has no jurisdiction to do it. Again, it is clear law that in order to redress a wrong done to the company or recover money or damages alleged due to the company, the action should prima facie be brought by the company itself. And then the facts are again explained here, and I want to just go through this particular quotation of Vikram ji. It is only necessary to refer to the clauses of the Act, the Companies Act, which gave the separate legal identity to the companies, that whilst the supreme governing body, the shareholders, the proprietors, at a special general meeting assembled, they retain their majority powers, they retain the power of exercising functions conferred upon the Act of Incorporation, which today would be Articles of Association read with the Companies Act. And remember, this is in 1835, so they're using the Act as the reason for this majority rule. It cannot be competent to individual shareholders to sue in the manner proposed by the plaintiffs on the present record. The very fact that the governing body of the proprietors, the shareholders, assembled in the general meeting may so bind even a reluctant majority is decisive to show that the frame of this suit cannot be sustained while that body retains its functions. And then again it was reiterated in the McDougall case. In that case, the chairman of Emma Silver Mining Company had adjourned a meeting of the company without putting the question of adjournment to a vote. So this was a violation of the company article, you can say. The article must have been that every shareholder would have a right to vote on adjournment. McDougall was that shareholder. His right, his personal, you can say his personal right was breached, maybe. The shareholder brought an action seeking a declaration that the conduct in the meeting was improper, and it wanted a restraining order to disallow the directors from taking any further action on the resolution. Court of Appeal in this case said that the issue was that it was internal management of the majority to decide whether that breach was ratifiable or not. Mellish J said that if you allow this action, it would be completely useless. Because where the conduct complained of is capable of ratification by the majority in general meeting. This is, you can say, an implicit concept that even if an article is breached, the majority has the right to rectify that wrong. And then he notes that if the majority abusing their powers and are depriving the minority of their rights, that is a separate thing. If the personal rights of the minority are being infringed, and you know, there's then this fine line between what are the personal rights. Like, definitely it's a contractual right of every shareholder that the articles should be observed. But there may be some voting rights which are very, very essential, that it makes it personal for them because it affects their shareholding. And there are always going to be decisions which do not affect any individual in her individual capacity. And we'll see that there are instances where Foss was not followed because that situation does not fall within the scope of Foss was Harbottle. And then continues to say that, but if what is complained of is simply something that the majority are entitled to do has been done or undone irregularly. Again, he's admitting that there would be a breach of the articles in such context. But since they can accept it or reject it, then it is quite right that nobody should have the right to set that aside or institute a suit in the court except the company itself.